Okay, continuing about the litigation in the States, the current wave of climate change cases are being brought in the individual state courts as opposed to the federal courts. And this is for a very good reason, because of the preemption of public nuisance claims in the federal courts because of the Clean Air Act. The current suits are being fought with three basic complaints about the oil majors. Their use of fossil fuels, the sale by them of fossil fuels, which are then burnt by others and then cause greenhouse gas emissions. And thirdly, the fact that many of the oil majors have been alleged to have been funding climate change, denying science, within a view to preventing regulation of their activities by governments and authorities. A sort of basic sort of misrepresentation. The cases of New York and Exxon and City of Oakland and Exxon, those have seen victories for the oil majors. They have got them out of the state courts on the grounds that these claims are interstate in nature. And then when they're in the federal courts, they face two big problems. First of all, as regards greenhouse gas emissions within the US, the claims are going to be preempted by the Clean Air Act. With extraterritorial emissions, which is part of the claim, you run into the issue of the presumption that US statutes do not apply extraterritorially, and this seems to have been extended so that there is a presumption that you can't make tort claims extraterritorially. And the judges in both these cases have seized on bits of obiter dicta in the Alien Tort Statute case of Jesner to justify this conclusion. But there have been victories for the municipalities, particularly in two tort suits by the City of Baltimore and by Rhode Island. In 2019, they managed to get their cases sent back to the state courts. In the Baltimore case, the federal court said, look, it's got to go back. There's no question of any federal question in the claims which are being made in the state courts. For a start, federal common law doesn't govern your state law nuisance claim. The oil majors haven't shown that there's any federal common law claim for nuisance, and in any case, the Clean Air Act would displace any such claim. Secondly, there's a small category of cases where when the claim raised in the state court raises substantial and disputed federal issues, that it becomes appropriate for the claim to be heard in the federal courts. Now here, although there were federal interests involved in the claims, because clearly the federal government in the US has got a clear interest in addressing climate change, the district court in Maryland said that the oil majors hadn't established that there was a federal issue in the case. Foreign policy concerns, the federal regulatory scheme under the Environmental Protection Act, and also the Clean Air Act, these were not necessary elements of the nuisance claims which were being advanced by the municipality, City of Baltimore. Thirdly, they said, well, this doesn't implicate the foreign policy of the US. I know the US is involved internationally in various agreements, but that doesn't mean that we are going to be treading on the toes of the executive in hearing these public nuisance claims. And also the Clean Air Act doesn't preempt Baltimore's claims. We're suing in the state courts. The Clean Air Act, in fact, specifically preserves existing rights of action. Well, there's actually 8 grounds of challenge which were made by the oil major defendants, and they failed on all of them. Another one is that some of the oil majors' activities took place on federal land owned by the federal government, and therefore, because of that, it ought to be heard in the federal courts. And the Baltimore, the Maryland court just rejected that. It wasn't substantial enough. It came to an appeal to the Court of Appeals for the Fourth Circuit, and they gave their judgment on the 6th of March 2020. And they declined to reverse the first instance decision that the case should be sent back to the state court. Now, one of the reasons why the appeal was simply on the issue of what is called the federal officer question. Some of the defendants had contractual relationships with US government bodies. There were 3 particular contracts which were pointed out, and therefore it was said that if you are suing them, you are suing them as acting under some sort of federal authority, and those type of claims have to be heard in federal courts. And again, that was one of the grounds which was rejected. That's the only ground on which an appeal could be made. In March 2020, the Court of Appeals said that there isn't a good enough reason. You're not actually making a claim against federal officers or people working under the authority of a federal officer. The oil majors are not done with that at the moment. They are going to have a go at appealing to the Supreme Court. They have issued what is called a writ of certiorari, which is an attempt to get the Supreme Court to hear a particular legal question. And the legal question they want to ask is, if you are appealing on the grounds of the federal officer question, you should be able to have all the other grounds of the judgment against remand. You should be able to have all of them challenged. I suspect that is, I would very much be surprised if the Supreme Court wants to hear that. It looks pretty clear that from the wording of the relevant statutes that the only thing you can appeal against an order that you are going to send it back to the state courts is on this federal officer basis. So there we are at the moment in the States. There are appeals going on in the New York case. There's an appeal going on in the Oakland case, and there's also another case by California municipality, that of San Mateo, which came to a different conclusion from Oakland. And so the Court of Appeals is was going to hear that appeal along with the appeal by Oakland, and it heard oral argument back in February. We don't know when the judgment will be on that. Now, all this is jurisdictional tussling. We've got nowhere near anything on the merits yet. So it'll be interesting to see what happens in a year or two when we actually come to trial on some of these cases. So we're now going to turn away from the United States and have a look at another common law jurisdiction.